And first thing we're gonna do tonight is I'm gonna call the meeting to order, and I'd like to see, we have a full quorum. OJ's recused himself, am I correct?
I will when we start talking about the cell tower.
Okay,
And if you want, I'll make a motion that we pass over consideration of meeting minutes and move right into number 3, the continuing other business for the GMR Holdings of New Hampshire LLC cell tower.
I have a second.
I'll second it.
All in favor? Okay, good. Motion passed.
Aye.
Yeah, I'm fine. You can't see me.
Tamara's gonna sit in for OJ, correct?
Correct. I'm recusing myself as of right now.
So, Mr. Chair, just for the record, can we say who the attendees are tonight's meeting?
We
So we
will.
have-
Give me a
yeah.
time, Paul. Give me a minute for everybody to get settled. I will.
Okay,
Now we have Mark Erman, Tammy sitting for Peter. Steve's on.
Tammy's in for who?
Steve is on,
Tammy's in for OJ, not Peter. Sorry.
correct. Mark Erman's on. Paul's gonna be sitting in as an alternate. And we're gonna move. Okay, first thing we're gonna do is making sure we get the right people on here. As you noticed, the last meeting was closed, the public hearing at the conclusion of the December 9th meeting. The planning board wants to open public hearing. They should approve so the motion.
It's done with the last meeting.
Joe, do you want a motion to open the public hearing?
Please,
I'll make a motion. We open the public hearing.
second. We have a second,
Mark Herman seconded it.
so noted. Now, for the public hearing part,
We got to vote on that?
all in favor of opening the public hearing?
Aye.
Opening.
Aye.
All right.
Now, do we have any new discussion?
Anything from the public?
Any oldest? Any new comments from the audience?
Can I comment over yours? Probably not.
I'll make a motion. We close public comment.
We need a second.
Wait a minute.
Oh, wait a minute. We had Peter Spanos. Hang
I
on.
didn't think it.
I submitted pictures because I didn't see the ones where they superimposed the cell tower like they said they would on the photos that we took. So we submitted some new pictures.
Did they get them?
Did you get them? Did you look at them? Does anyone have any comment? I talked to Phil Bryce at the Franconia Knott State Park, and he wasn't, committal one way or the other, what he, how he felt, but he would look into it. I don't know if anyone heard anything or if this even matters.
I believe in today's packets, we had the planning board. It was an imposed tower over the balloons.
Okay, yeah, I did,
I
do have,
one from GMR Holdings.
I just don't feel it's a very good representation of what it's really gonna look like. Compared to what the balloons look like, but whatever you guys have to do it.
Well, they just printed a new one today, Peter. I just got it in the packet this afternoon, which shows a superimposed one. Looks like a regular tower would look like. I don't know if you've seen it or not.
Is that the black and white ones that were sent in today's packet, Joe?
I
Wait,
did them in color.
It's
Sorry.
Color.
Those were emailed to you all at the end of the day after Peter sent them.
The tower is drawn in red ink, is that correct?
That is correct.
Yeah, thank you.
Talking about the ones from GMR Holdings, which are more drawn to scale. I received in my packet.
No,
Okay.
there's another email
Wasn't from Peter.
from Lisa that was cell tower photos. That was emailed today at 2:58 PM. And those have the 4 pictures that Peter Spanos is referencing now.
Because I got a package of a regular photocropped one, not just hand drawn, in the packet today. Email, I'm not sure which.
I don't know if I hold it up if you can see it, but I can try.
It's not that, and it's not that at all.
No,
I-
it's
I
in your
haven't seen
email,
that one at
Joe.
all.
Oh,
It's in your email, Joe. It's not in your packet.
okay,
Would you like to see if I can screen share those? I may have them in my email.
Yeah, it's worth a shot. That would be great, Ron. Thank you.
Well, is it okay with the chairman to do that?
please please proceed forward with it.
So,
Just for the record, I mean, John Springer, on behalf of the applicant, we submitted our visual study 2 months ago, whenever it was. Whatever got emailed out today is the same thing from our side that I walked through at the last meeting, and I had all the pictures up on the screen.
Right.
Lisa may have taken a few pictures out to highlight those, but those are the same ones we submitted previously, to my understanding.
No, the ones that are being shown now are ones that were submitted by Peter Spanos.
Right.
That he
Okay, yeah, okay.
submitted that he wanted to share. Now, if we were in a public meeting, he would have brought them and shown everybody.
Yeah.
Obviously, you can't do that, so we're going to screen share them instead.
Okay, I misunderstood what you said. Okay.
No worries.
And John, there was a photo that came out, was a regular cell tower overposed over the balloons that I get this afternoon in my email. Not from Peter, but somebody else.
Those are from
Okay.
Lisa. Those are ones that John previously submitted.
Right.
That's the one I didn't see. I didn't get that one before.
can I,
Thank you, Ron.
go ahead, sorry, Tim. Go
No
ahead.
worries.
No,
You're
if
good.
I want to say, it just comes to the aesthetics of the notch. We lost the old man. That was bad enough. Our attendance for our tour groups going through Franconia Notch dropped 85 to 90% because they said, why bother going through without the old man? Why even look at the notch? Like it's nothing worth even seeing, which, we always try to, educate them, and it's difficult. But now with the cell tower there, it's going to make it even harder. That's my only point.
Thank you, Peter.
Thanks.
Any other public comment? Being no other public comment, close the public discussion.
So
You have a
moved.
motion. I made a motion already.
We-
Paul motioned and I seconded.
okay. All in favor?
Aye.
So moved.
No, you're good.
Oh, perfect. Thank you very much. My name is Jane Ludwig, and I'm a resident here in town.
Jane, we closed public
Yes.
discussion. You have to reopen if
Oh,
you
you
want to
closed already?
Yeah.
I just got home.
speak. Anybody, do we have a motion to reopen it for Jane?
Move to reopen.
Second,
Second.
all in favor?
Aye.
Aye.
So passed.
Thank you. My name is Jane Ludwig, and I've lived here over 40 years. I've traveled to Notch 30 years for employment. Through rain, sleet, snow, without a cell phone for many years. And I know that I'm kind of wasting my breath as I talk, because I know that it is something that we have no choice over, which I feel is extremely sad, that we don't have a choice over whether a cell tower is placed on the entrance of the notch. Once upon a time, I hiked all the mountains several times with a map. I didn't have a cell phone and I didn't need a cell phone. In fact, sometimes I lose service in the notch. There are two places outside of beginning of Franconia and the outside of Franconia where I lose service. I lived through it all. I believe the tourists that I've talked to want to come up here and see a pristine area. They want to see a place when they can go in the woods and not see hundreds of people. That's what the White Mountains, in my mind, was always about. If you want to start to modernize it, to think that we actually need a cell phone to go hiking, in my personal opinion, you shouldn't be hiking. If you don't know the trails, if you can't read a map, if you can't use a compass. I'm sorry, my dog's barking.
Sure that wasn't Steve?
So it actually, it breaks my heart that this is happening and we can do nothing about it. This is what I hear. And it breaks my heart. If you want to put a cell tower in, put it up. You've been putting them on top of all the mountains. I've watched that progress. I've watched the mill go under, come back up and go back under again. And to see this is like beyond what I think that we should represent in Lincoln to the people who really want a place where they can come and get away from things. And if it's just for AT&T, or the governor decided, or President Trump decided, I don't know, but it's unfair that we really have no say in what our town looks like, what our town should and should not have. And when you have a Indian head, Mr. Spanos and his family have been there as long as I remember, and if it's gonna impede their business, if they don't want it there, we should think about what they have to say and believe in what they have to say. I don't think communication is all that important up here. It is to an extent, but if people get lost in the woods, they shouldn't be in the woods. I just feel really brokenhearted about it. I really do. Thank you for listening.
May I respond
Please do.
briefly? I'm going to be very brief. I don't know if Ms. Ludwig has been in these hearings before. I say this with all due respect, but she says the town doesn't have a choice. In fact, we are going exactly where the town ordinance tells us to go. I can't say this enough. It's not President Trump. It's not the governor. The town said, the town said, go to this parcel. We went there. I mean, there's no argument about that. We are a permitted use in a permitted zone.
Then why are you?
So I can't, excuse me, I'm talking. So if you don't like that, I'm sorry, but we're going where we're told to go, number one. Number two, the purpose of this site is not to bring coverage to hikers on trails. It's not. We've been all over that. I'm not going to repeat it. Our materials are at length about what we're trying to cover here, and it's not the hiking trails. You're not going to see this from the hiking trails. And I'm sorry, I keep getting interrupted. So it sounds to me like somebody, well, I'm just going to stop. I can't even get a sentence in. I've made my points. Thank you.
Excuse me, Mr. Chair.
I've heard you talk, and I don't want to argue with you, sir.
Jane.
Well, let me finish, please, and I'll get off this thing.
Jane, the chair has
I don't
to
want
run the meeting.
And
Mr.
who
Springer
in
has the
town
right to
told
finish
you
his comment.
that you had to bring this up here?
Okay, Jane.
All right?
Come on, Chair. Mr. Chairman, run the meeting, will you please?
So from now on, only one person talk at a time and be recognized.
Well, I'm tired.
Anybody else have anything to say?
Peter Malia has his hand up.
Joe,
Joe, could you recognize
over
Peter?
here in this box.
Go ahead.
Well, the town does have a say in this, Jane. A cell tower is a permitted use in this district, but only with site plan review and approval, and that's what they're here for. And there are a number of decisions that the planning board has to make tonight. So the town does have, I don't know who you've been talking to, but the town does have a say in this. And tonight, they'll be taking a number of votes regarding this application.
Right. Well, that's good to hear, Peter. Thank you. I hear that doesn't go without retaliation. So that's kind of my plan. That's where I was coming from. And I did hear that we had no choice.
These applications are different than others that the planning board deals with because the cell companies have a great deal of federal protection from the Federal Telecommunications Act. There's also a state law. So in addition to Lincoln's ordinance, which is usually pretty much all you're dealing with, we have the state regulations and then we have a Federal Telecommunications Act as well. So it's more difficult if a town or a municipality denies one of these applications. It is more difficult to have them upheld on appeal. First of all, rather than being appealed to Grafton County Superior Court, they're appealed to federal court, and it's sort of a different ballgame. And but it's not, it's not impossible to have a denial of one of these applications upheld on appeal. It's difficult. It depends on the basis for the denial. But like I said, the planning board has some decisions to make tonight, so we'll see how the meeting goes.
Yeah.
Joe?
Do you know of any situation, Peter, where there has been denial on them?
Did she raise her hand?
And they won? Oh, I'm sorry. And they won?
Thank you.
And the town won? Do you know what a town that won?
It has happened. I can't cite to one right off the top of my head, but it has happened. John probably could, but
Okay.
he probably doesn't want to.
Okay. Thank you, Peter.
Paul, you have anything else to say?
Yeah, Joe, I just want to also point out to Jane that I think it's important for those people and planning board members who may be concerned about legal damages, that according to the New Hampshire Local Government Center, it states that the court may not order that a municipality that loses a court case on violation of the Telecommunications Act pay the applicant any damages or attorney's fees. So that's according to my read from the New Hampshire Local Government Association. They try to make everybody work together. And I think this is a way that they try to make everybody work together.
Any other comments from the general public?
Motion to close public hearing.
Second,
All in favor?
Aye.
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 Aye, so moved. Now we're going to begin our deliberations as on the case. Oh, darn it. On a conditional use. The first one shall be request for the Honeyfoot. It states that the planning board shall first vote on the applicant's conditional use permit request for 120-foot tower. Article 6, Section A. Article 6A, Section 5. States the maximum height for a communication tower should be 100 feet. The planning board can increase the height of a tower as the planning board makes three findings. 1, the intent of the ordinance shall be preserved. 2, the modification of the height of 100 feet limit is necessary and appropriate for further purpose of the town communications and ordinance. 3, the modification is necessary to allow for the provision of telecommunications service in the area of the community affected. Anybody want to go vote on the first one?
I'll make a motion that the intent of this ordinance will be preserved with a height increase to 120 feet. Once we have a second, we can discuss.
We have a second? But as a chair, I'll make the second to discuss it.
Thank you. The only point I really want to make is that with 100, increasing it to 120 feet puts the base of this tower lower. If we don't agree to increase it to 120 feet, they're just going to submit an application to move the tower up 20 feet up on the hill. Doing that, we lose a lot of trees, we lose a lot of cover in that area. Either way, they're going to achieve that 120 feet, whether the base of it is down on the parking lot or the base of it is 20 feet up on a hill. So I don't see why we wouldn't allow them the additional 20 feet to preserve the trees that are up on the hill and keep the base of it down low. That's the point I wanted to make. I saw Paul had his hand up. Sorry, Paul, I think I cut you off.
All right.
Go ahead.
Yeah, Joe, with respect to what Tammy says, it's not a foregone conclusion that moving that up on the hill would be a permitted use as well. But I think the intent of this ordinance will not be preserved by doing this, allowing this to go from 100 to 120 feet. It does not promote the safety and welfare of the buildings located within the fall zone of the proposed tower. Further, as the applicant correctly states, a 100-foot tower is allowed in this district and that they could move the location to the top of the knoll. However, the applicant would still need to meet the setback requirements and fall zone requirements. And by the looks of the site map, it would require substantial site modifications. So I'm not quite sure that moving this to the top of the knoll is a foregone conclusion. So I don't think that the intent of this ordinance is preserved by making this from 100 to 120 feet.
Any other comments from the board?
This is Steve. I agree with Paul. They made the 100-foot limit for a reason. I think that's enough for me.
Who's on here?
Mark is the only other one, Joe.
There he is. What do you think, Mark?
Well, the problem is I don't know the facts as well as probably you do. I mean, the representation is that they'll just move it to the top of a ridge that has trees on it that we want to protect. And therefore that our insistence on the 100-foot limit will have no net effect on the ultimate height of the apex of the tower. However, Paul's point is detail sensitive, meaning we don't know, I don't know where the exact location of the ground features is compared to the limit of the plot, etc. So it's possible that their representation is not exactly accurate. So I don't really have a net opinion on the thing. I would like to see either an architect's or an engineer's opinion with respect to that particular site. And in terms of preserving the safety of I know Paul is focused on the fall zone issue. For me, the fall zone issue is seems less important because it's a stayed monopole tower. And a stayed monopole tower, which is properly erected and is properly designed to collapse if the compression forces along the stays are sufficiently high, would pose, I think, negligible risk to surrounding buildings. Except in circumstances where no sane person would want to be outdoors or in the building anyway. So, all in all, in terms of the impact on the visuals, I can't see that the impact would be that different if presuming that the argument about putting the tower on the ridge is correct. But I don't know if that argument is correct. And in terms of the effect on the effectiveness of the tower to move it up 20 feet versus not move it up 20 feet, assuming that the base remains in the parking lot area. All we've seen really is a projected map of the signal strength as a function of location with a 120-foot tower in the parking lot versus a 100-foot tower at the top of the ridge containing the trees. What we haven't seen is a map of the affected signal strength of a 120-foot tower in the parking lot versus a 100-foot versus a 20-foot shorter tower in the parking lot. In other words, if we grant versus don't grant the variance, and if they choose nonetheless to locate it in the parking lot, what's the effect of that choice on the signal strength in various locations throughout the distribution zone and on the transmission rate, the ability to achieve 5G speeds, et cetera, et cetera. I don't know the answers to any of those questions. And since I don't know the answers to any of those questions, it's hard for me to have a net opinion on the effectiveness. I suspect that the visual impact of the extra 20 feet will not be substantial, but that's just my guess. That's not my, I don't know that. I'm just guessing that. I realize that the tip of the monopole is the ugliest part of the whole lump, and it will be higher in the air and therefore more visible to some extent from up in the notch and so on. But how much more so, I really don't know. I don't think all that much more. So my thoughts are not simple, and I don't have a punchline. I don't have a bottom line conclusion on it. Those are what I thought.
Excuse me, Joe, just to tap on one thing, Mr. Springer commented once on why they needed the extra 20 feet at the parking lot level, and I don't want to misquote him. So can I ask you, Mr. Springer, Attorney Springer, there was a reason why you needed that extra 20 feet if you place it where you intend to.
Yes, I guess what I would say is there's going to be no difference. And I thought I saw Ivan Pagasic on this call. Yeah, I see him. Ivan can chip in if he thinks I'm wrong, but there's going to be no appreciable difference in the RF footprint if we build the 120-foot tower where we're proposing to do it versus a 100-foot tower on the top of the hill, because the top of the pole is essentially going to be at the same area, and we're only in terms of above ground, and we're only moving it, however many feet over. So the RF footprint, I don't expect will change.
Right, but can I ask, I believe Mr. Ehrman was curious if you put a 100-foot pole where you are currently proposing the 120-foot pole, does that leave you with a large deficit in your coverage?
That will reduce the amount of coverage. I would note, it doesn't solve the fall zone issue. And again, getting back to the original point of this discussion in terms of the intent of the ordinance, the ordinance says you got to try to save as many trees as possible. And that's what we're trying to do. And if we thought, we were going to get we could have just come in at 100 feet on the knoll, and we wouldn't be talking about this extra 20 feet, and we'd still be talking about the fall zone. So I don't see how anybody can say at 120 feet where we are doesn't advance the intent of the ordinance, because we're keeping all those trees, we're getting the same RF bang for our buck, and the visibility isn't going to change.
Mark Ehrman has his hand up.
Can I answer your question? Yeah, I guess.
I'd like to ask Mr. Springer a question, because with due respect, he didn't really address my issues. In fact, he just reiterated his prior statements, and they hadn't addressed them. So the question, John, is, number one, how far laterally displaced is the point on the ridge where you want to build it now with the 100 feet versus the 120 in the parking lot? What's the distance from one to the other? That's the first question. Do you know the answer?
Well, I got to look at the plan. You're probably talking about, hold on. I would say maybe 20 to 25 feet.
Okay, and what if any are the implications in terms of setback of your ability to use the ridge site? Are there any, do you have a problem with the ability to use it or not?
Apart from the fall zone, I don't believe we would.
And what about the fall zone issues for the ridge site?
We still run into the fall zone issue.
Well, running into it, that you know, the question is how much so? I mean, you must have one intersects of the fall issues with the tower at the top versus the tower at the bottom.
I'm sorry, I didn't mean to interrupt you. I started answering.
Did you do a comparative drawing of one versus the other? I mean, it's not a simple yes or no answer. Either there is a problem or there isn't. It's a qualitative and quantitative answer as well. So did you analyze that? Did you look at it?
I'm sorry, Mr. Herman, I'm not sure. When you say, did we look at what? I'm sorry, I missed.
Do a calculation for the fall zone issue. You don't get a yes, there's an issue, or no, there's not an issue, unless one of your sites is in the Antarctica and the other site is in Manhattan, in which case you might get a yes or no answer. But if you have two sites that are 25 feet apart and they're both where the site is, you're going to get a qualitative and quantitative answer that's going to have both drawings and potential consequences on it. The drawings or plans or schematics are going to show possible adverse interactions with buildings or other things. And they're going to show anticipated consequences, and they're going to try to quantitate them or qualitatively describe them and compare them. And it might take you a paragraph and it might take you 10 pages, depending on what's in the zone. I don't know what's in the zone exactly, but you do.
I guess the only thing I can say to that is if we move over the 20 or 25 feet and we put up a 100-foot pole, we are still within the 125% radius of the building on our site. So we would need to ask for the fall zone waiver in any event. And because the 100-foot pole is now elevated by round numbers, 20 feet additional ground elevation, it's going to come out, I think, to the same thing in terms of we would have to engineer the pole to have the buckle point. If you recall where we talked about that, it bends, it doesn't break, et cetera, et cetera. I don't think that's going to change. I mean,
with due deference, I think that's a question that is an engineering question or an architectural question much more than it is a legal question.
But we're still within the 125%.
I understand you're trying to turn it into an on-off, into a binary issue, and my position is, or my point was, and I must tell you, I'm not trying to make this into more than it is. I'm just trying to get an answer to a simple question, and the answer might be you haven't examined that. In which case we might or might not want to look at it. I don't know. I mean, I'm not claiming that it's the most important thing that ever happened. I'm just telling you it's an issue. Because, for example, if you were going to impact a building, right? And if the place that you were going to impact the building in Plan A was on a garage that occasionally contained a dump truck, right? Then you might have one reaction to that. Whereas if the point that Plan B would impact a building, if it did have a fall problem, was a dormitory that contained 40 children, you might have a very different reaction to it. And that's a qualitative and a qualitative issue because it involves costs, it involves downside risk to people versus non, et cetera. And those are kinds of questions that can be answered by an architectural study, by an engineering study, but not by a legal answer that says there's an issue in both cases, and therefore we don't need to ask the question. I think it's a question. It might be a very different thing. It might be very similar. I don't know. For all I know, all the impact zones are the same, and they don't matter that much. But there are places that matter more and places that matter less. and manners of having a failure that matter more, and manners of having a failure that matter less. And those are the kinds of issues that civil engineers and architects deal with a lot, and that lawyers don't deal with that much proactively. I mean, no offense, just telling you what my point is, that's all. So.
None taken. And I'm just telling you what my point is. I see Peter Cook's got his hand up, so I'm going to ask him to respond as well. But the only thing is that the nature of the building we're next to doesn't change. It's not, I mean, whether we go on the top of the.
It doesn't change.
Hold on, I just listen to you, please. Can I please speak without being interrupted? Thank you. I don't mean to be short with you, but I listen to you. Now, please. The nature of the building isn't changing. Whether we go on the top of the hill or in the parking lot, there's not going to be a dormitory with 40 children in there. And honestly, I don't even know where that example comes from. This is a commercial building. Yours is and we talked about this before. You missed the last meeting, Mr. Ehrman. I don't know if you saw this in the notes, but as Mr. Robinson pointed out in his learning about this industry, and I can tell you, I don't know of any other fall zone except this town's fall zone that includes a structure on the host property that has to be away from the tower. We have our landlord who consents to this, and the nature of the building isn't going to change. And we think what we have presented is a fair representation. That's the best I can tell you. And I would ask for Mr. Cook to be recognized to chime in because I saw his hand up. Peter?
Thank you, Mr. Chairman, if I might, and Mr. Ehrman, to John's point, I mean, I understand that you're concerned with the fall zone and how it might impact that building. I would tell you that one of the major reasons that we have moved it is that the current location is on the really the back side of the hill. There is an abutting house immediately to the south that would be much more impacted by the loss of the tree height. So there obviously, I understand the concern with whether or not the top 30 feet of the tower is going to hit the building or the top 60 feet of the tower would hit the building if it were to fall. But I think the real advantage from a planning perspective here is the impact to the residents immediately to the south of the property, who has provided his opinion that he much prefers that the tower be located where we are proposing it rather than on the top of the hill because of the potential loss and impact to his property, which I think when you weigh that against how much of the pole is going to hit the host building is a much more important issue to think about from a planning perspective.
Thank you. That is responsive to my question, and I appreciate your input. Thank you.
Thank you.
Hi, Joe, it's Paul. Hey, look, we're talking about this fall zone, and that's going to be discussed in the section on the waiver. We're looking right now to discuss whether the intent of the ordinance will be preserved. The intent of this ordinance was to keep that fall zone part of it, and it was to put it in a district where if it did have that problem, it would not cause any issues. It was also the intent that, and as you look around in Lincoln right now, you'll see several of the cell towers that have been constructed that are totally not within any building sites at all. That was by design. That wasn't just by happenstance. The loss of the trees that everyone is concerned about, I have yet to see the plan that would show all of the loss of the trees and why they would have to lose those trees and why this monopine, why they couldn't have installed a monopine instead of a monopole. So, I mean, some of that would have taken away the loss of the trees too. I know we talked about that as well. And there's nothing that has shown where on top of that knoll, where, as Mark said, where it would be located, where the setbacks were. There is a huge cut right there on top, embankment right there, where from what I know of the site, where the new 100-foot pole would go, there would have to be, I would think, some substantial modifications made to that in order to be able to put a tower on that knoll. But without seeing a plan or anything like that, it's really hard to say. So it's hard to discuss this 100-foot tower on this knoll because we have nothing that shows what it would have looked like anyway. All we've been presented here is truly a lot of facts that pertain to the 120-foot tower. The majority of those facts, the pictures, everything, it has been all about that. So, you know, the intent of this ordinance will not be preserved by allowing this to be the 120-foot, because we haven't seen what 100-foot on that knoll would look like or what other effects it would have.
Okay, any other comments?
Joe,
Peter?
before you vote, so.
I want to
just
make a comment too.
What's that?
I'm going to make a statement too,
You can go first.
because you look where that tower wants to be, the 100-foot tower would be on top of that knoll. The topsoil on that knoll is probably 6 inches deep. It's got second, third growth trees on it. And no matter whether we cut the trees or not, they will come down sometime because the topography and the structure of the soil and the sediment and waste was constructed. It's not a stable bank and probably never will be if the tower is put up there, no matter what we do. It's a drive piling down about 80 feet. Because what happens is, when I took classes with the Department of Interior and got a degree in logging and soil, trees, everything else, shows the trees up there only have a root system about 6 to 8 inches deep, if that. When they're all together, what happens is they all reinforce each other. When you cut some trees away, the ones on the edge will come down eventually, maybe sooner or later, maybe tomorrow, maybe next year, the year after, or 4 or 5, 10 years, but they will come down. Peter?
And just to make sure everybody's on the same page on the planning board, this is one of 3 motions that you have to approve in order to allow the 120-foot tower, the extra 20 feet. So if you want to allow the 120-foot tower, you have to vote yes to all 3 motions. By defeating any one of these 3 motions, then they don't get the extra 20 feet. They did submit a 1-paragraph explanation when they applied in response to each of these 3 criteria. I don't know if everybody had a chance to read that. I could read that paragraph to you if you want to, so that you can hear their explanation as to why they meet this particular criteria regarding the intent of the ordinance.
You read it, please, refresh our memory.
It says, okay, so what you're going to be voting on is a motion that the intent of the ordinance will be preserved with a height increase to 120 feet. They say the purpose of the ordinance, as set out in Article 2, is to guide and protect the development of Lincoln, to promote the health, safety, and general welfare of its residents, to protect the value of the property, and to prevent the overcrowding of land. In this regard, it is important to realize that the applicant is siting the monopole on a low spot on the property. The applicant could move the proposed monopole to the top of the knoll immediately to the south, a distance of perhaps 60 feet or so. In so doing, the applicant would gain approximately 20 feet in height, meaning the applicant could use a 100-foot monopole. However, in so doing, the applicant would be forced to remove some large trees. As seen by sheet Z3, there is a 75-foot hemlock, a 70-foot hemlock, and a 60-foot maple, all of which are currently being retained, but which would have to be removed. Those trees provide good tree coverage / visual coverage for the monopole. Allowing the applicant an additional 20 feet in height at the proposed location means that the top of the monopole would be roughly the same as if the applicant moves the monopole slightly to the south at the compliant height. Thus, by this proposal, the top of the monopole is roughly at the same height, given the difference in the ground elevation, while retaining significant tree coverage.
Okay. I make a motion. I have some.
Paul has his hand up.
Tammy?
Paul
Yeah.
has his hand up.
Hi, Joe, it's Paul. And I just want to state again that as was just said, that the ordinance is there to protect and promote the health and safety of the general welfare of the residents. By allowing this to be put there, it does not do that. And we cannot assume that moving it to the knoll would be an appropriate place to move it because we haven't seen its location. It is, we don't have the information to be able to make a decision that says that this protects the intent and of this ordinance. And I would not, I'd make a motion that it does not protect the intent of the ordinance.
We'll be up for a vote in a second. Anybody else have any comments? Okay, motion to go and to close the discussion and go to a voting on this particular item.
You can
We
just-
only do,
you can just
we only
call.
do that in the DA, don't we? Do we need to
We're
close?
doing each one separately, Paul.
Yeah,
One,
you
two,
can
and three.
call the vote, Joe.
You
The
just
mo-
call a vote, Joe.
motion was,
We call a vote for this one, number one.
The motion was that the intent of this ordinance will be preserved with a height increase to 120 feet. I made the motion, Joe, you seconded, and you can go ahead and call it.
Tammy?
That's true. I stand corrected.
All in
Right,
favor?
Tammy.
Aye.
Aye.
Can you restate the motion, please, exactly, because it's unclear to me.
The motion was, I made the motion that the intent of this ordinance will be preserved with a height increase to 120 feet. I say aye, Joe said aye.
I would have to say nay because we don't have the information. But if we had the information, we could pass a true vote, yea or nay. But we do not have all the relevant information in my.
So
Opposed?
Just a minute.
the
Paul,
vote's been taken and
we gotta have all 5 people vote.
you only have 2 supporting it and 3 haven't voted. So I'm
That's what I'm
assuming
asking, the other 3 to vote. For the record.
I'm a nay.
Steve,
Steve is an A. I'll say it twice. Nay, nay.
so it was defeated. So we don't even need to continue with the other 2 criteria.
You should continue in case there's an appeal so that the court has your opinions on all of the issues.
Fantastic. So I will make a motion that a modification is reasonably necessary and appropriate to further the purpose of this article.
This is the second conditional use requirement, the second out of 3, that the modification, the increase to 120 feet, that's the modification, is reasonably necessary and appropriate to further the purposes of this article. And if you want, I can read what the applicant wrote in support of this
Get a
request.
second? I made the motion. Did we get a second?
Sorry.
I'll
Joe, did
second
you-
for the purpose of getting it on the board.
So
Did
Joe
you second,
seconded.
Joe?
Yeah, please.
Do you want me to read the applicant's paragraph in support of this?
You get all the data right there.
The additional height is reasonably necessary and appropriate to further the purposes of this article. The purposes of Article 6A regarding the height issue are to reduce adverse impacts, including impacts on aesthetics, environmentally sensitive areas, historically significant locations, and flight corridors. See Article 6A, Section A, 3B. Further, subsection C of that section encourages co-location. The facility addresses all of these concerns. It is important to keep in mind the applicant is permitted a height of 100 feet by right. Accordingly, the applicant is only asking for an additional 20 feet of height. This additional height will not adversely impact any environmentally sensitive areas, historically significant locations, or flight corridors. It will also not impact the aesthetics of the area. Allowing the 20 feet additional height will also provide for additional co-location spots on the tower.
Mr. Chair,
Well,
I'd like to comment here that the additional height is not necessary. as stated by the applicant, if he can prove that this could be put on top of the knoll, the additional height is not necessary. But if they could put it on top of the knoll, it would still have to meet all of the cell tower requirements pertaining and the regulations pertaining to setback and fall zone. The impacts to the aesthetics, as I said earlier, could be mitigated by the construction of a monopine. And I do believe that therefore this modification is not reasonably necessary. Again, because we don't know the impacts of what would be affected if it was up by the knoll. We cannot just assume that it would or would not be allowed there. So it's not reasonably necessary to say that it needs to be 120 feet.
Any other comments? Mark?
Well, I think we're really looking at the same issue from a slightly
We
different.
got to vote on all three, Mark. That's what I was asking. We have to vote on all three criteria. This is the second one.
I know it's the second one. I'm just saying it's not the way it's stated. It's broken out. It's not that different in terms of the amount of information we have about it. And Paul's comments are on point, so I'd vote against it as well.
No, we didn't-
Mr. Chair, I'll make a motion that we, you already have a motion in a second.
Yeah.
Can we just say all in favor? Aye. And then opposed?
Opposed or aye? Steve?
Steve, nay.
So it's 3-1 without the chair voting.
Make it
Joe?
two.
Joe, you voted? Are you voting?
I had my hand up saying yes, but nobody
Yes, okay.
could go through.
The 2 yes, 3 no. So for the third one, I will make a motion that a modification is necessary to allow for the provision of telecommunications service in the area of the community affected.
I'll second it.
Thank you, Joe. Peter, would you like to read that third one?
Sure, this one's a little bit shorter. They said a modification is necessary here to allow for the provision of telecommunications in this area. The required additional height has little, if any, impact on any aesthetics or other concerns. However, it will provide AT&T the ability to provide RF coverage to a significant gap in coverage and will allow additional co-locators to use this facility as well.
Mr. Chair?
Recognize.
I think that throughout the process of these meetings, the general public has expressed much concern about the impacts on the aesthetics here. There are obvious concerns about creating different visual impacts to this area. The safety impact of this property is not normal and would require a waiver to be constructed, excuse me. The applicant is not entitled to a perfect surface, and the FCC explicitly allows gaps in dead zones. Therefore, there's not a need to allow a conditional use permit to increase the proposed cell tower from 100 feet to 120. The modification is not necessary to allow for the provisions of the telecommunications in this area. Sorry about that. I messed up something, but yeah. It's just not necessary to do it because we don't, there's been a lot of people who have taken time to show up to these meetings in regards to the aesthetics and express their concerns. And I think this board has a responsibility to listen to them. And a lot of them are longtime residents.
Anybody else have any comments?
Call it, Joe? All in favor?
Just a minute. You might want to note that the North Country Council sent an affidavit in for an item they've been pushing is a North Country communications is needed to supplement business and increase it. That's what they had, one of the minutes I have, one of the notes I have from them. So I'd read into the minutes. Tammy, go ahead.
Well, I'd like to make one more comment before you do that, Joe. I just want to make sure that everyone today got the email that came out from the planning from Philip Bryce.
I did.
You did? Joe, did you get that?
You got
Steve
that, Phil?
and Mark, did you get that as well? I'm sorry, Mark, but you're muted.
I didn't see that. I thought I read everything.
I did, but I'm just looking to see if I can reread it, that's all.
It's short and sweet. Do you want me to read it?
Sure.
Yeah, I've got it right. Yeah, go ahead.
Dear Town
Okay.
of Lincoln Planning Board, I received a call late today that you were in the process of reviewing the siting of a telecommunications tower off of Route 3. We participated in the balloon test, observing it from a number of key locations in Franconia Notch State Park. The one location where there was clear visibility was from just south of the Flume Gorge exit. We would urge you to give full consideration to the visual impact of the tower on visitors headed into one of the highest ranked state parks in the US. I apologize for the late response. However, I found out about your meeting late today and have been in meetings since. Thank you, Phil. And that was Philip Bryce, Director, New Hampshire Division of Parks and Recreation.
Thank you, Tammy.
You're welcome. Nothing
Tammy,
else?
you want to proceed with your motion?
We're all in favor? Aye. All opposed?
Nay.
This is Steve, nay.
Mark, are you up?
Yea or nay?
I said nay.
Joe?
I'm going to abstain because of other reasons.
Okay.
I would like to add a comment following the vote
One moment, please.
when it's appropriate.
Proceed.
Well, my comment is that, as I've expressed before, I recognize the economic and other reasons for wanting to have the cell tower, and I agree with them. And I would like to have a cell tower in that location as well. However, I think that the way that this has been presented has not really transparently compared the alternatives. And in the language and with the structure of the legal decision tree that's been presented to us by our council, and I think by the laws as they stand or by the regulations as they stand, I can't vote for it because of that. We don't have the information to answer those questions. So for example, if they were to modify their proposal and show more data in a more transparent way, it might be that they might get approval for a monopine tower, let's say, in a somewhat different location. And it also might be that the exact height of 120 feet versus 100 in the two different locations is not in fact imposed by the facts or by the data, but is imposed by a choice that's somewhat arbitrary. And there might be a better solution or a more aesthetic solution that could serve the interests both of the telecommunications and of the people who want to preserve the appearance of the area. And I think we should strive to find a solution that is better for all parties. That's my comment. That's why I voted against the proposal as it stands.
Thank you, Mark. Joe, if I may, I'm just going to read out, the planning board finds against the applicant on all three of the conditional use permit motions. So the applicant's request for the 120-foot tower has been denied. Do you want to move on to the waivers, Joe? Because I'll read that now if you'd like.
Please do, Tammy.
Waiver number one, the applicant noted that the town stormwater management ordinance requirements do not apply to this application because the development at issue does not disturb 15,000 square feet or more, or 50% or more of the square footage of the lot. In this case, the area of disturbance is approximately 3,000 square feet, which represents approximately 6% of the lot area. I would like to make a motion to grant a waiver from Article 1423D of the Lincoln Site Plan Review Regulations.
I'll second it.
All in favor?
Any
You want some
discussion?
discussion?
Tammy, could I ask you to explain your request for that waiver in a little bit of detail? Is that a position of yours? And if so, just tell me a little bit about the pro and the con as you see it.
Are you asking Attorney
Can I go
Springer?
first, Joe?
Yeah.
You
Mark,
No, I was asking Tammy actually, but
oh, okay.
fine for her to refer it to somebody else.
Go ahead, Peter Millian.
Peter has, yeah.
Little background, Mark. So here we flip over to the site plan review regulations from the telecommunications ordinance. And the site plan review regulations require 4 stormwater drainage items, 3 of which they've provided or don't need to apply. So they're in compliance with 3 out of the 4. The one that they are asking for a waiver on is D. It says engineering calculations used to determine drainage requirements. So it's the engineering calculations. I had some back and forth with Ray Korber and John Springer. John submitted a letter to the town dated January 5th, which you should have. He makes a proposal that they'll withdraw this waiver request if the board, and they'll agree to a condition of approval if they're ultimately approved, that will require them to supply the planning board with the calculations that are required using a HydroCAD stormwater modeling software to calculate the existing and proposed stormwater conditions. So they're not necessarily refusing to do the stormwater work. And I think the proposal made by Attorney Springer, in my opinion, seems reasonable, that they withdraw this waiver request and we impose that condition if they're ultimately approved for the 100-foot tower now. It's not a 120-foot tower anymore. You could get Ray Korber to weigh in on this if you'd like. He's on the Zoom call.
Is Ray Korber,
Just a minute.
Ray, are you here?
Yes, I am.
Ray, can you give me a guesstimate of the rough, very ballpark cost of doing that calculation? And how much time it takes and roughly how much it costs? I mean, does it cost $1,000? Does it cost $10,000? Does it cost $100,000? What is it? And how long does it take? A day, a week, a month, a year?
No, I mean, it's something like that. The site is very small in terms of its footprint, and the area that, based on the information that's been submitted, the area of impact, there's about 1,000 square foot area of trees that would will transform into, as I understand it, a gravel footprint within the footprint of the cell tower site. So that's the impact. So this wouldn't be a big effort for them to make a determination to meet that requirement, provide engineering calculation to meet that.
Ask you one more question while you're on the subject. So is the impact limited to the final layout around the tower itself, or is the impact also limited to the transient disturbance during the construction and creating the stays and so on, and the ingress and egress of heavy equipment in order to accomplish the work? So, for example, take those trees on that ridge. If you were to pick that ridge as the site that you were going to build the tower, it might well be that you would, in fact, as others have stated, disturb the subsoil or the soil in such a way that those trees would be destroyed, with consequent effect on the watershed capacity and so on, regardless of what your ultimate intentions were as to the site. Is that true?
Well, if I understand what you're asking, I mean, essentially you would look at it, I think you have two components there. The first component would be a load bearing capacity of the soil relative to the structure that's going at a specific location. That's one technical issue that needs to be addressed. The other technical issue would be the runoff that's coming from the site. And the runoff issue is the biggest driver there would be a change in the surface. So if you go from a woodland or a forested site and you're turning that into a parking lot, obviously you're going to have more runoff that's associated that's coming off of that particular site. And on this site, everything basically flows downhill from the highway through the site and down to Route 3. So they're, if you're replacing, a wooded area with a gravel footprint, obviously you're going to increase runoff from that onto Route 3 in this case.
If you're causing a change in the vegetation indirectly from the, let's say, heavy equipment, then that's going to also impact it.
Yeah, but that's what you're describing there. There's what we call the, they've addressed the erosion and sediment control issues relative to the construction activity. I think we did have a comment. We did ask them to make some revisions to their plan in our comments back in early December, I think it was. We submitted those comments. And those comments were related to the temporary erosion and sediment control measures that would have to be implemented during the construction of the facilities. And then there's the second component, obviously, is once the facilities are built, what is the additional runoff that comes from the site long term? So that's where the engineering calculations would come into play, and that, relative to the issue that's on the table as we speak.
Thank you, Ray.
Mr. Chair,
Where are you?
right here, Joe.
You on
I
the
guess
other
I'd
side of the page before.
like a little explanation of why a waiver is even required if they're not going to disturb 15,000 square feet.
I'm sorry, Paul?
Why is the waiver required if he's not going to disturb more than 15,000 square feet?
Well, the 15,000 square feet is the threshold in your stormwater management ordinance. So yeah, they don't trigger that threshold, but you have a site plan requirement that they need to submit drainage calculations. So that's what's triggering this.
But they don't have to do a stormwater plan because they won't disturb 15,000 square feet. They will still have to submit some calculations, and they still will have to do some sedimentation and erosion, but they will not have to submit a stormwater protection plan as it stands in our ordinance. Am I correct?
Under the stormwater management plan, that's correct. I mean, if they don't, I mean, there's a lot of different ways and methodologies that they can approach providing calculations to show the planning board what the pre and post development runoff is going to be. And at that point, the planning board would have to decide whether that's, in your opinion, whether that's excessive or not. If
Right.
that's problematic or not. There isn't anything in the site plan regulations that I saw that establishes what that threshold is. I think that's going to come down based the way the town's articulated.
Right. I mean, we haven't imposed that on too many people before that have disturbed less than 15,000 square feet. So therefore I would think that they wouldn't even need a waiver because they're not going to disturb that 15,000 square feet.
They don't need a waiver for the stormwater management ordinance because they don't trigger the stormwater management ordinance.
Right. And that's what this waiver is asking for.
No, this waiver is asking for a waiver on your site plan requirements.
Which requires engineering calculations used to determine stormwater drainage requirements is what it says.
And I understand
that's what I'm reading.
What do you say,
yeah,
Pete?
my understanding is that the waiver is requesting, they're not now, but they were requesting a waiver on Article 23D of your site plan requirements. That's different than the stormwater management ordinance.
I don't have the application right in front of me, so
Malia has his hand up.
Just a minute, let Peter Mayer go.
Yeah, Paul, if you look at my agenda there on under waivers number 7, it references the Lincoln Site Plan Review Regulations, Article 1423D.
yes, I've got that.
But then the next paragraph I took from the applicant's project narrative. Their explanation as to why they should get a waiver from the stormwater drainage requirement in the site plan review regulation talked about the stormwater management ordinance. So it's a little confusing because they're two separate things. But I think the bottom line is that they're offering to withdraw the waiver request and provide the stormwater information as a condition of approval, which maybe Ray can weigh in on whether or not he thinks that's a reasonable way to approach this issue.
Ray?
Yeah, I think that's a reasonable way to approach this issue, given the the size of this development. again, it's a small footprint, and in talking with the applicant's engineer, it's highly likely they'll be able to demonstrate there's not a significant impact between pre and post development drainage, which I believe the planning board would want to know about.
Right. So it'll be appropriate at this
Go
time to
ahead.
make would it be appropriate at this time to make a motion to pass over waiver request number 1?
There's already a motion and a second, so I would have to withdraw my motion first. So I will withdraw my motion.
And I seconded it, so I'll withdraw my second and make the motion that we pass over waiver number 1 because the applicant has requested it.
I'll second.
All in favor? Wait a minute,
Aye.
Peter,
Yeah, just for the record, the applicant has waived, the applicant has withdrawn this waiver request and proposed a condition of approval, and the planning board has accepted the applicant's proposal.
Perfect.
So we took a vote. Did everyone vote?
no, we didn't. We stopped and mid.
No, we all did. I believe we all said aye.
Well, yeah, I wasn't sure,
Just
Jamie. I
like
think
the
you're right.
US Congress, we're not going to count the votes.
Make sure no one's in the building. Yeah, aye. Steve, where you at?
Yeah, I'm with y'all.
Okay.
Well, I'll assume that's a yes. So then you want me to move along, Joe, the second waiver from the telecommunications ordinance, Article 6A, section H4AI, which states towers shall be located within the tower lot so as to provide a fall zone free of any structures equal to 125% of the height of the tower. In this case, the height of the tower is it's not 120 feet anymore, it's 100 feet. Therefore, the 125% fall zone requirement for this is all.
So where it stands now is that the 125%, I think they still need the waiver because Attorney Springer, I think earlier said that the commercial building is still within the radius, even if the tower is 100 feet. And so where it stands now is that the 125% fall zone requirement for a 120-foot tower amounts to a 125-foot radius, not a 150-foot radius, which it would have been for a 120-foot tower. So,
But I think,
for
Peter, I have
100
a question.
Let him
I have a
finish.
question for you, Peter. In regards to this waiver is for this application. It is application specific. If the applicant wants to reapply for a 100-foot tower on the same lot, that would need to come in underneath a separate application, I believe. And therefore that waiver would need to be requested at that time. To request the waiver now, based on this, I'm not sure it's appropriate. And I think it should be part of a new application. If they want to put the 100-foot, because they're not asking for permission to put a 100-foot tower here. They're asking for permission to put the 120-foot tower. So to give a waiver based on that doesn't seem to be, in my opinion, relevant to this application.
Peter,
One way to look at it, I would maybe look at it a little bit differently. They requested they proposed a telecommunications tower. They requested a conditional use permit to go from 100 feet to 120 feet. That's been denied, so I'd now treat it as a 100-foot tower. And they still need a waiver from the 125% fall zone requirement because their commercial building is within the 125-foot radius for their tower, which is now 100 feet. So I'd suggest that you go through the 3 waiver requirements for a 100-foot tower.
I'm not sure that I agree with it, Peter. And the only reason I say that is because I think it's a whole separate application. It would need, depending on where they were going to put it, are they going to put the 100-foot in the same place as the 120-foot? Or is it going to go up on a knoll? If it's going to go up on a knoll, it's in a whole new location. The abutters, the notifications for people, the balloon test, all of that then become again, part of a new application. I'm not trying to string this out. I'm saying it would be a new application because you would have to go through all of that to be able to show people what a 100-foot tower would look like on that knoll.
Okay, so you're proposing that the board proceeds to decide the waiver request for a 120-foot tower.
Yeah.
Okay.
I mean,
I actually, I think you've talked me into it, Paul, because if there is an appeal, then the court can compare apples to apples instead of apples to oranges.
Correct.
If there is an appeal, the judge can see how you dealt with the conditional use permit, and the judge can see how you dealt with the request for a waiver from the 150-foot radius. So let's go ahead and decide what they asked you to decide, which is a waiver from the 150-foot radius for a 120-foot tower, and go through the 3 requirements for that waiver.
Thank
So
you.
I'll make the first one, I'll make the motion that strict adherence to the requirements of the 125-foot fall zone requirement is not required to effectuate the purposes of this ordinance.
Could, before that comes up, I'd like to ask,
Second to discuss. We need a second if you want to discuss it.
I'll have a second.
Thank you. Now I would like, oh, can you recognize Mark?
Tammy, you should take Joe's place. You're doing a good job.
No, thank you.
I'd like to ask Peter a question, which is that we have been discussing the whole fall zone issue, presuming that the applicant can obtain a release or has the non-written agreement of the owner of the commercial property to suffer the risks of the fall zone at his own or her own risk and expense, cost and expense. So my question is, presumably we'd also require an indemnification for the town and for any third parties from the parties granting the waiver, so that there's no liability transfer, contingent liability transfer to the town or to any other parties who might be injured by this. And so let's presume that we've made that requirement, because it seems reasonable to request such a hold harmless agreement in exchange for waiving the fall zone requirement. Does that seem like a reasonable condition, Peter, for granting such a waiver?
I would say that you can impose that as a condition of approval. If the applicant didn't think that was reasonable or appropriate, then they could challenge that condition. Even if the applicant didn't challenge that condition, say you imposed it as a condition and they provide it. If, God forbid, there's a catastrophe and a fatality or serious injuries, and there's a lawsuit brought, then the town would, I'm sure, be named as a defendant, and the planning board or the town would then point to this condition of approval and the hold harmless agreement which we had signed, and hope that that got us off the hook and out of the lawsuit. So yeah, I think you could impose that as a condition of approval.
Well, the reason I'm saying it is because I believe they've already represented that it, quote, it doesn't matter because the building owner has already stated that he would waive, he or they or he or she would waive responsibility in some fashion. So since that leaves out parties that haven't been mentioned, I would just include those parties and make it a little broader and request.
Joe, are you here?
Paul has his hand up. Go ahead, Paul.
Oh, all right. So my comment, Mark, is that I had previously brought this up at one of the hearings and asked if they would do a hold harmless agreement and protect the town and take on the liability should something happen in the tower fall, whether it was only the top 40 feet or the whole tower. And the response I got was no, they would not do that. So unless that's changed, and we'd have to ask the applicant, then I don't know where we go from there.
Well, if there is a requirement for them to fulfill the conditions about the fall zone, why is it reasonable for us to waive it without any protection or compensation? I mean, that doesn't seem reasonable to me.
No, it doesn't. That's why I asked. Attorney Springer's on, and so, I mean, I would think that he would comment one way or the other if they were willing to do that. If not, then we can move on to
An insurable
with our-
risk. Oh, it's an insurable risk. And since it's an insurable risk, somebody who's better at quantitating the risk than we are, namely an insurance company and an actuary, can make a calculation as to what it's worth. And if it's as negligible as they represent, then the insurance would be very cheap. And it would be silly for a person who wanted to put a big deal to say no because he had to pay a few bucks for an insurance, for an additional clause on an insurance policy. He's going to need liability insurance for it anyway. Let him just go for that particular clause. It's not a big difference.
Mark, I'm not arguing with you, Mark. I'm just asking the applicant if he's willing to do that.
Paul, let me ask the applicant. Mr. Springer, do you have any comments?
I do. First and foremost, we were never asked to provide this to the town. The discussion before was there was a question put to Mr. Malia about the town's liability. And the response from him was the town board does not incur liability by approving an application, period. End of story. We were never asked to provide this, number one. Number two, if you can point to me in the ordinance where we're supposed to provide this, we would do it. But at this point, with all due respect, we're in deliberations. My client's in traveling here, and you're asking me a question to provide you with something that is not required under the law, under your ordinance. And, yeah, Peter's right, or Mr. Malley is right. I suppose you can impose it as a condition of approval. But to say that, we should, we said no previously is not correct. And to put the question to us now, when, with all due respect, it's pretty obvious where, this hearing is going, is unfair, quite frankly. So that's my answer. And I guess the answer is no, we're not going to voluntarily provide that.
Mr. Chair.
Just a moment. Anybody else have any comments? Just a minute, Paul.
Yeah, then what I would like to say is that this waiver should be denied due to the fact that strict adherence to the requirement is required to affect the purpose of the ordinance. The proposed 120-foot tower, which will require 150 feet free fall radius, would impact the current building on this parcel. The building's not only used as a commercial building, but has living quarters and office space, which could be occupied daily. Protecting the safety of the individuals from any possibility of harm from the installation of this project is not a barrier. It is an obligation to this board. The strict adherence to the fall zone is required to effectuate the purpose of this ordinance. The waiver, if granted, would create a different and inherent safety impact, not only to this property, but to the community in general. And this fall zone was put in to protect life, property, and the requirements of the ordinance. So
Any
that
other comments?
if you look around, well, I'm not finished, Joe. If you look around,
Get on with it.
this town is not anti-cell tower. And Mr. Springer has made several assertions about the way this meeting's been gone. He's wrong. He just needs to take a look around and see some of the other cell towers who have complied with the intent of the ordinance in this town to know that we allow cell towers. We know that they're necessary. What you're missing is the ordinances that the people of this town have voted on to regulate them stand. Thank you.
Any other comments?
Yeah, I'd like to comment that it's not necessary for the applicant to state that he would submit to a condition precedent in order for us to vote on whether or not we should impose a condition precedent. So the applicant doesn't have to volunteer to pay for the insurance, but we are perfectly entitled to ask or to insist that such insurance be provided, because that will at the very least give us a measure of the anticipated risk of the events we're talking about. I mean, if the insurance company says they won't cover it, that'll tell us a lot. And if it says we'll cover it for an extra $250 on your general liability policy, that'll tell us a very different message.
Joe?
Peter Valiant has his hand up.
Quick comment on the indemnification issue. I think that Attorney Springer and Paul and Mark are all right. I am recalling the conversation we had that Attorney Springer referenced, in which when we talked about this at our last meeting, I think Paul brought it up, the indemnification issue. And I did talk about how, generally speaking, municipal boards have a great deal of discretion from discretionary decisions that are within their statutory authority. So it is difficult, very, very difficult to sue a board for a decision that they are permitted to make under New Hampshire law and that they make after a great deal of deliberation with a number of public hearings. So there's very little, I think, liability to the town. But if you did want to, further protect the town, as Mark said, you could impose such a condition, and you don't necessarily need the applicant's permission to impose a condition. You can impose a condition if you think it's appropriate. There have been occasions where boards have imposed conditions which applicants have felt have been illegal and unsupportable, and sometimes applicants will appeal the condition and courts will decide whether it was appropriate or inappropriate. And finally, I do recall Paul, during the course of the discussion at a prior meeting, asking either Attorney Springer or his client if they would indemnify or hold harmless the town. And I think maybe it was met with silence, is my recollection, but that's neither here nor there. But I think that was my recollection of how that conversation went.
I think it was Peter Cook or someone who said no, is my recollection. And the final comment I would like to make is that, with all due respect, Mark, I agree with what you're saying, but I would also find it very hard to sleep at night if just because an insurance company said they would assume the liability and the risk and make a payment, that someone's life was lost because a tower fell within a fall zone. That is not, in my opinion, an acceptable risk.
Let's move on.
So Joe, the motion that was seconded was that strict adherence to the requirements of the 125% fall zone requirement is not required to effectuate the purpose of the ordinance. Those in favor say aye. Opposed, say nay.
Nay.
Hey,
Steve? Steve, you're muted.
I don't even see him on the screen.
well, whoa. Can we get a read from Peter Melia on what a yay and a nay is?
Yes, thank you. I'd like the motion restated because with all due respect, I found that hard to follow.
Yeah, me too.
I'm off it now.
So a yay, so again, just to make sure we're all on the same page. Earlier with the conditional use permit for the increase in height to 120 feet, there was a 3-part test. And likewise, for a waiver from the 125% fall zone requirement, there's a 3-part test. It's not the same test, it's a different test. But number one is that they have to prove that strict adherence to the requirements of the ordinance is not required to effectuate the purposes of the ordinance. And so that's the way the motion was made, that strict adherence to the requirements of the 125% fall zone requirement is not required to effectuate the purposes of the ordinance. So if you're in favor of giving them a waiver from the fall zone requirement, you would vote yes for this motion. And if you're opposed, you'd vote no.
So no, so just for my clarification, a no vote means that they would need to comply with the 125% fall zone requirement.
Well, there's two more, there's two more criteria after this one, but a no vote here means that you think that the 125-foot fall zone requirement is required to meet the purposes of the ordinance. And so you're voting against their request to waive that provision.
Peter, it's 125%. And the simple summary is no means no waiver, yes means waiver. Is that right?
Correct.
Okay, so can we revote this, Mr. Chair? So we now know?
You want
So the motion that was seconded was, I make a motion that strict adherence to the requirements of the 125-foot fall zone, 125% fall zone requirement is not required to effectuate the purposes of the ordinance. All in favor signify by saying aye. Opposed, nay.
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 And that is.
This
all
is Steve. Can you hear me now?
I can hear you now, Steve. Yes, thank you.
I can hear you, Mr. Chair.
I'll move on to the second one if that's okay, Joe.
We'll see.
I'll make a motion that strict compliance with the 125% fall zone requirement would create practical difficulty and unnecessary inconvenience. Need a
Have a
second?
second?
I'll second that for discussion.
Joe seconded it, but thank you, Paul.
All right. I didn't think, I couldn't tell if his glasses, if his eyes were awake or closed.
Is there any discussion?
This is why I was recommending the alternative, an insurance policy. And I might say that in every construction project of any sort whatsoever, there's always a trade-off between some risk and some benefit. And that's true whether you're building a bridge or a highway or a school or you name it. And in this case, I think that the risks might be quite small, but I don't really know that. And I don't know how practical the impediment is to having the 125%, although it's been alleged and may be true. It's been alleged by the proposed developers. I have no information whatsoever on how impractical it is to respect it. And a good way of assessing how impractical it is once again by asking the people who judge the risks of such things for a living, namely actuaries, how risky it is. And the only way that I know of to ask them is to get an insurance policy, because that's how they do it. And if it's ridiculously expensive, or it can't be insured, or if it goes into an assigned risk pool, or if it leads to a great meeting of committees in 10,000 miles away, then it's got to be pretty risky. And if your agent says, sure, I'll check the box and it'll be an extra $100 a year, then it's not that risky. And that gives you a very good assessment of what we're talking about. I don't have a clue. So how can I vote that it's not important or is important? I got to have some more facts for that. Cheapest way to get those facts, get an insurance policy.
Personally, I think with this monopole design, the 125% rule is not that critical.
That's true, Joe. Then people who insure
The last meeting.
will say so. You know, I mean, it very likely is true, but we can find out.
Anybody else?
So
Peter?
the
Can I assume that it's, Peter, can I assume the motion, a yay and the nay would mean the same with this motion as it did in the last?
Yeah, yes is in favor of the waiver, and no is opposed.
Thank you. Want me to call it, Joe?
Just a minute. Okay, I can hear you now.
You want me to call it? All in favor, say aye.
Aye.
All opposed, say nay.
Nay.
Nay, Steve.
Nay. So Joe is I'll move on to the third one if you don't mind, Joe.
So, 1 second.
You're doing great, Tammy.
Thanks, Paul.
The pen's still following up. Go ahead, Tammy.
The third one, I make a motion that strict compliance with the 125% fall zone requirement could potentially cause a conflict with the Telecommunications Act of 1996 and FCC regulations promulgated thereunder. That's the motion. We need a second to discuss.
I'll second.
Paul, second.
Yeah.
Discussion.
I'd like to ask Peter a question.
Go ahead, Mike.
So Peter, how in the world did we get in a position in the planning board where we have to vote on a legal conclusion that is wildly beyond our competency?
Good question. I'm not sure where you got your telecommunications ordinance, but if this is in there. And I don't know, Mark, that it's in your ordinance. I'm not sure how it ended up there, but maybe it's a model ordinance that the New Hampshire Municipal Association came up with and you guys adopted, or maybe we got it from another town. I can tell you what the applicant said about this particular provision or requirement in the applicant's project narrative. The applicant says that the purpose of the Telecommunication Act and the FCC regulations is to remove barriers to the zoning and construction of these types of facilities. A strict interpretation and application of the fall zone here would create such a barrier.
I'd like to comment that the fact that we have to pass such a vote at all or consider an issue, which is clearly well beyond the competency of anybody on this board, with the possible exception of you, and I'm not so sure about you. No offense. Because certainly you've not had 100 cases on FCC Act violations or whatever. I mean, it is an indication that what we're in a position where we've been asked basically to stipulate something that is well beyond our competency. I mean, I'll stipulate, as the Tennessee legislature did, that the value of pi is exactly 22/7. I will, which is completely wrong, but I'll stipulate to it nonetheless. I'll stipulate to the day is night, but I won't stipulate to anything like this because I don't have a clue.
I feel the same. When I first read it, the first thing I thought was, I'm going to abstain on this one because, yeah, that's the same thing I thought.
I think that, first of all, no offense taken, I am not a telecommunications expert. I've had a couple cases over the years here and there regarding the Telecommunications Act, but pretty few and far between. The interesting word out of all of them in this particular provision is the word potentially. I mean, it's pretty easy to conclude that strict compliance could potentially cause a conflict with a very lengthy, detailed, and complicated federal act like the Telecommunications Act of 1996 and the FCC regulations promulgated thereunder. So, I mean, I think it's probably pretty easy to vote yes for this, that strict compliance could potentially cause a conflict with the 1996 Act and the FCC regulations.
Come on, Peter. That's you're being a linguist, but you're not being a lawyer, and you're employed by the town. So the clear issue here is we're being asked to say that something is true when we don't have a clue as to whether it's true or not true. So could it be? Sure, it could be. Anything could be, but no, I'm not.
Right. But I think Peter's correct that, you know, anything could potentially happen there. And, you know, this probably was better served to be answered by our, the person, what was his name? The gentleman who the town hired to review this.
Ivan
Yeah,
Takasik.
he's on. Is it Ivan?
He is. Ivan, do you care to weigh in?
Yeah, I'm sorry. I stepped away for 1 second. Can you repeat the question?
There was a motion and a second on the third requirement for the fall zone waiver. And that motion was that strict compliance with the 125% fall zone requirement could potentially cause a conflict with the Telecommunications Act of 1996 and FCC regulations promulgated thereunder. There's been quite a bit of discussion on it. Your thoughts?
I don't know the specifics on fall zone with respect to the Telecom Act. With regards to FCC and the Telecom Act, I'm not sure what the specific requirement coming out of the FCC would be with respect to fall zone, other than the FCC discussing in the Telecom Act the prohibiting coverage if there are gaps in coverage. But anything other than RF, I would defer to your attorney to weigh in on.
In the interest of moving on, would it be prudent to find to agree to this waiver?
Hell no.
It does no harm, Mark. What harm does it do?
Totally disagree with you, Paul. Due deference. You cannot sign gibberish because it could possibly be true. That's, pardon my French, but that's stuff that comes out of the south end of a north-facing horse.
So what do you do with it, Mark?
You've either vote it down or you state for the record that it's not an appropriate resolution for this body to pass. I mean, that's what it is. It is not an appropriate. It is crafted by somebody who's intent on being able to present a document to the court which shows that we stipulated to something that we are clueless about.
Can I call the vote? The motion was that strict compliance with the 125% fall zone requirement could potentially cause a conflict with the Telecommunications Act of 1996 and FCC regulations promulgated thereunder. All in favor, say aye.
Aye.
Opposed, nay.
Nay.
Nay, Steve's a nay.
And I'm going to abstain. So it was defeated. So the planning board finds it.
Can I chime in? I only counted 4 votes, or how many, who voted on that and which way? I'm missing a vote.
That was mine. I voted yay.
I voted yay.
Yay. Mark and Steve were nay, and I abstained.
Okay, all right. Thank you.
And the applicant's request for a waiver from fall zone requirement is denied.
Okay, Mr. Chair.
Sorry. Go ahead, Joe. Now you can move on to number 9 there.
Go ahead, can run it. Go ahead.
Peter, can I ask a question for the record? I know you've talked about, and John has talked about, if this could or may go to court. And I'm not trying to make light of the situation, Tammy, but we have a vice chair. And can this be challenged because our vice chair is not running the meeting? I mean, can Tammy, Tammy's got to run the meeting. I just want to make sure that's okay. That's
a minute. I'm just going to read this out and then it's all on him.
Look, I'm just asking,
No,
parliamentary
that wouldn't be a basis of challenge. Joe's still here. He's still running the meeting. He's deferred a couple of things to Tammy, but Joe's still in charge.
Thank you very much. I just had to ask the question
Sure is.
for the record.
So now we need to discuss the criteria set forth in Article 6A, Section I3, which are the factors to be considered when making a decision on a telecommunications tower application. Do you want to read those out, Joe, or would you like me to?
Hey, Peter,
Yeah.
if we've already shut down 2 items, is it necessary to continue with the rest for the time being?
I would finish it off. It'll give them maybe if they do want to reapply, it'll give them a sense of your thought process on the rest of these criteria. If there is an appeal, the court will see that you decided everything that you had to decide.
Should I make the motion, Peter, prior to going through A through K?
Why don't you read each one and ask any of the board members if they have any comment on each one?
Okay.
You want to
so
do that?
The height of the proposed tower or structure. We've already denied it
already-
at 120 feet, so it would be 100, which is allowed. Any discussion? B would be the proximity of the tower to residential development or zones. The fall zone waiver was denied. Any other comments?
If I could, back to A,
I'm sorry.
the request, I mean, the application's for a 120-foot tower. You denied the conditional use permit. I think if they want a 100-foot tower, they have to reapply. They don't get a 100-foot tower tonight.
Correct.
I would agree with that.
Okay.
Joe? You
So
agree with that?
That's what you said earlier.
Steve, you agree with that? Mark?
I have no opinion on the matter of whether they have to reapply or not. But if I'm not sufficiently conversant with the process issues involved, but either way, I would be in favor of considering such an application favorably, subject to this issue.
Thank you. Was there any discussion on B, proximity of tower to residential developments or zones?
I think, yeah, Tim, I think we discussed that as well by the fall zone. And its location and proximity to other buildings.
Agreed. C, the nature of uses on adjacent and nearby properties. Any discussion there? D, the surrounding topography. Any discussion there?
I think you've kind of discussed that too with the Knoll issue.
We did. E, surrounding tree coverage and foliage. I think we've discussed that as well. Any other comments?
I would like, okay, never mind.
Okay. F, design of the tower with particular reference to design characteristics that have the effect of reducing or eliminating visual obtrusiveness.
I would like to make a comment that the applicant, if he decides to put the 100-foot tower in, will consider the use of a monopine, at least consider it or show it as an alternative
Or possible option.
or possible option. Yeah, whatever. Yeah.
Sure. Did you hear that, Mr. Springer? Yes. Thank you. G, proposed ingress and egress.
Excuse me,
Sorry, go ahead.
Ms. Ham, I heard, I'm not sure where the criteria is you're walking through. What section are you looking at?
Could you?
It's Article 6 dash
6A.
section 1(3).
That's it. Sorry. Yep. 6A, section I3, 1(3).
I'm sorry, Tammy, you're right. I think it is.
This is the ordinance or the site plan, right?
G was proposed ingress and egress to the site. Is there any discussion there? H, availability of suitable existing towers and other structures. Is there any discussion there? There isn't really a tower to cover anything in that area. There is an AT&T tower on the other side of town.
It doesn't cover it all.
I agree. No, I agree. I think we've discussed it. Is there any other discussion?
Well,
Paul?
no, I think at one point I did have a question about whether or not, and I posed it, I think, to Peter, about whether or not one company could use another company's tower signal. What do you call it when you do that, when you buy
Co-locate, I believe they're
It's
required.
not
to
co-locate. It's
It's
not
not.
co-locate. What do you call it, Peter? What's the word?
Roam?
Roaming?
Roaming.
Roaming. And then, the answer came back from Ivan, that it's a legal question, that needed to be looked into as to whether or not we could ask, as an option to installing a new tower, whether service could be extended to, an applicant based on, using roaming. And there didn't seem to be any clear answer when I had asked that question.
There's one big problem. There's no other town in that section of town.
Right.
I seem to have pretty good cell service going through there, Joe. I gotta tell you.
I've gone before without any.
Ivan, anything else you want to say about this roaming issue?
Well, I think you just need to look at that because roaming does not provide coverage for the applicant's service. You're forcing them to utilize another carrier's service. And I don't believe that, and I'm not sure, I'm not a lawyer, but I believe that the act doesn't have provisions for roaming, and it's specific to a carrier's own network.
See, I mean, my question to further, it, when you make that kind of comment, Ivan, is that the town does require people who companies that install cell towers to provide the ability for other people to place their equipment on there. So that's why I brought the question of whether or not, that equipment could be used to extend roaming to the availability of other people companies who want to use it.
Yeah, really, the co-location is really meant to foster competition and allow for other carriers to install. That's really the intent.
Okay. All
Thank
right.
you. Moving on, visual impacts on view sheds, ridgeline, and other impacts by means of tower location, tree and foliage clearing, and placement of incidental structures. I think that's been discussed verbatim with the balloon test, the photos, et cetera, et cetera. Anybody else have any comment? Yay, the availability of alternative tower structures and alternative siting locations. I think we kind of just talked about that a little. Paul?
I have some. I'd like to see the applicant provide some sort of written documentation from either the state of New Hampshire or the National Forest Service that would demonstrate why the lands were not available. And a memo from Peter on August 15th of 20, he stated that the properties were eliminated from consideration as not only are generally unavailable for lease. And then Mr. Springer, Attorney Springer, stated that the U.S. Forest Service has requirements as to how one can go about seeking to place a site on national forest lands. I think that it would be, I would like to see written documentation as to, whether or not this property can be used and what it would take. I mean, we obviously have Cannon Mountain on National Forest Service. We have the Flume up on the National Parks area. We have the basin.
New Hampshire property.
But there's two different properties that going through the notch. One is the state national parks, and the other is the White Mountain National Forest. So there's two entities there. But my point is that I'd like to see why the applicant really can't use those. I mean, Loon Mountain uses some of them. So there are possibilities out there to be able to use, I think, some of the governmentally owned and state-owned properties. Does it take a little longer? Probably. But in this case, it may be better suited. I mean, we put an interstate through the Franconia Notch. There's no reason why we couldn't put a cell tower. That's much. So anyway, I would like to see a little more documentation as to why, whether it is available or not and why.
Peter, you had your hand up?
Couple things to clarify. Paul mentioned an August 2020 memo from Peter. That was from Peter Cook, not Peter Malia. That was this alternative siting analysis. And
Yes, I'm
Paul,
sorry.
it sounds like what you're saying is that if they reapply, you'd like to see something from the Forest Service saying you can't come here because, or maybe in the alternative, they can. You'd just like to see something from the Forest Service?
Yeah, I mean, there's, as I said, there's two entities there. One is the White Mountain National Forest Service and the other is the New Hampshire Divisions of Parks and Recreation, I think, or state parks. So there's two entities there that you could deal with to possibly,
There's also,
effectuate, that could effectuate, maybe something, a better location, a better, something for the applicant.
there's also a third, Paul. To the
Who's
east
that, Joe?
side of 93, that belongs to the state as surplus property. I don't know if you know that or not. Does belong to
No.
state forest, does not belong to national forest. Was purchased in 1970 for $1.1 million from George Cater, second Presidential Range Corporation, from given funds by the federal government so they could access roads to go through the notch. They paid the state to buy it and for the road for 93.
I learned something tonight, Joe. Thank you.
Thank you. All right, moving on, K, compliance with the stormwater management ordinance. I believe that was also discussed. Does anyone have anything else to say on that? Then I'll move on. I'll make a motion that we approve the application for site plan review submitted by GMR Holdings of New Hampshire LLC for a personal wireless service facility located at 749 US Route 3.
So I'll second it, but
We have to make a positive motion and then vote it down if you don't want it.
I'll second it.
Thank
But
you.
I do have questions. I mean, it appears tonight that we have rejected most of the applicants' request for the 120-foot tower. Does the applicant wish to withdraw his application at this time and resubmit one for a 100-foot tower? Or do you want to still stay with the 120-foot request?
Actually, that's a moot point. Because you already said he couldn't combine both items in one meeting. That was per your request.
I just asked the applicant if he wanted to withdraw his application based on what's happened here tonight. Wasn't
No.
like,
Nope.
no? Okay, all right.
Nope.
Thank you.
Then I would respectfully
discussion?
request that based on the actions of the board and the votes on the board tonight, that we not approve the application.
So you vote no to deny the application, which you basically have to do because you've denied the conditional use permit and the fall zone waiver. So this is kind of just a formality to conclude the case.
Okay, the motion was to approve the application for site plan review. All in favor, say aye. Opposed, nay. Nay.
Nay.
Joe?
Very done. Well done, Madam Chairman.
Thank you for your time.
Unanimous.
Bye-bye.
Thank you, Mr. Springer.
See you, John.
OJ, come back, please.
Yes, please.
Hi, guys.
There he is. He's smiling.
You're out of jail. You're out of jail.
Peter Malia, is Peter Malia still there?
Yes.
With this decision, doesn't there have to be a reason for denial of the whole application written as part of the decision? Can you talk to the board about that? Does it have to be just because of the two waivers weren't given, or do we have to go through A through K or L or whatever number that we worked up to and say these are okay and this one isn't?
Well, no, I think we should, yeah, I can write up a notice of decision. There definitely has to be a written notice of decision. And it's based on the denial of the conditional use permit and the fall zone waiver. There's no way it could have been approved at the end. So the final motion was just kind of a housekeeping way to conclude the case.
I guess
And if-
my question with that though is like, you talked about the influence of aesthetics on the ultimate decision. Now, if we said the aesthetics were fine, we don't have any problem with the aesthetics, but it's just the height in the fall zone, is that going to make a difference in an appeal versus if we said the aesthetics was not approved anyway, so that if they appeal, it has to be the fall zone, the height, and the aesthetics?
Yeah, I mean, we could, if, I guess that's a good point. If any, so planning board, I guess, taking a look at those.
Well, I would add to that, if I may, sorry about that. I would add,
I was just gonna say, we should get John back
Thought
for
this
this.
meeting was over.
I was just gonna say, we need to get John back for this if we're gonna
mean,
discuss this.
Peter, listen, Peter Cook just sent me a text saying they're still talking. I come on, and OJ Robinson, with all due respect, who recused himself, is talking about what's gonna happen on, I mean.
Wait a minute, I'm gonna defend this.
This meeting has got to be over.
No, it
Period.
doesn't.
Stop talking about us.
We were discussing the
board has to give you- I have the- Mr. Springer, this board has to give you.
I'm the chair here.
I mean, I don't know what, well,
Mr. Springer, excuse me.
Don is right. We should not be discussing this after the fact.
you took the vote, you denied us. I said.
Joe, could you recognize OJ, please?
Talking about it.
Joe, could you please recognize OJ?
Mr. Chair,
Not for this subject.
Mr. Chair,
Go ahead.
I would respectfully ask that this board inquire from Mr. Springer if he would want to go back into session so we could finish up the housekeeping on the notice of decision.
We did not end this session. What session are we going back into, Paul?
The
We,
hearing- the hearing.
John Springer, we said we left him with the intent that we were done.
Correct.
And Mr. Springer left. You came back on and you started talking about it, and I believe Mr. Springer is right. You recused yourself and you came back on and started talking about it. So we need to get some housekeeping here, and that's why I asked about who's the chair and who's this and who's that. You know, so I think the applicant is owed some
Technically,
honesty
I'm still the chair.
here and to say, you know, would you mind if we continued on this journey?
I do. The meeting is
Okay.
over. You took the vote. With all due respect, and again, this is not personal with Mr. Robinson. I'm just saying, he can't talk to you guys about this case.
I agree.
Accused. And so the meeting is over. You took the vote. You can't talk. Well, I've said what I've said. I'll just sit and listen and take careful notes, I might add.
John, I totally agree with you.
Peter?
He sets you up.
Peter,
first, Tammy?
He asked the attorney a question. That was it. He made no comment on the applicant or the application or any other discussion. He asked the attorney a question regarding the notice of decision. That is it.
True. I think John's point is well taken, though. OJ's question, I think the board was ready to move on to the next agenda item, and OJ's question did result in the board kind of continuing on or going back to the application for the monopole. So I think that I tend to agree with Attorney Springer. The vote was taken. The application was denied. I think if we had wanted to include any of the issues under, A through K, such as the citing issue as a reason for the denial, we had the opportunity to do that and we didn't. So I think we've denied it because it failed to pass the conditional use permit requirements. It failed to pass the waiver requirements regarding the 150-foot radius. And those are the reasons for the denial.
can we move on to the next agenda item?
I think if anybody disagrees with me, they could make a motion to revisit the denial, but I
As
think
chair,
otherwise you should move on.
I'm not gonna revisit it unless somebody wants to vote against it. Not revisiting. Let's move on to the next item.
I would like that, Mr. Chair, I would like to ask Peter if he thinks that we need to revisit it in order to clarify.
I don't.
Okay, then I would move that we go on to the next item on the agenda.
If I could just interject, this is Ray. I don't believe you need me anymore. Yes, no?
I think we're all,
Mr. Chair? You all set with my time?
the chair now is Jim Spanos, if we're all.
Yeah, I'm also, we're moving on to the other agenda items.
So Ivan can drop off as well, and I don't think you need me anymore either, do you?
No, we should be all set.
Okay, I'll write up a notice of decision for you, Joe.
Thank you.
Okay, good night, everybody.
Thank you.
Thank you.
All right, so the next item on the agenda is proposed changes to the land use plan ordinance for the 2021 town meeting. I have this here, Cal gave you with all the changes. I'm gonna work from that. Have you all read it?
Well, I just got mine late in the day, so I really haven't had a whole lot of chance with it, but you have I think you have a full board without me anyway, so, right?
We do.
Steve, you, OJ, Mark,
Yeah.
Yeah.
You'll be an alternate going forward.
yeah, there's no one missing.
All right. So let's go. Carol actually just included the copies of the ordinance, so they're in order, but they're in the order, they're right from the ordinance. So page 19, number 42 is an addition. Restricted multifamily residential housing. A multifamily residence with single entity ownership whose use is restricted to long-term tenancy, which is defined as greater than 180 days. The type of use will be considered a business use. This type of use will be subject to the business use density requirements in each zoning district. Does anyone have anything about that?
There's one thing, it says business use only, but renting rooms is a business.
What's that again, Joe?
You rent rooms of any kind, short-term and long-term, it's still a business.
Joe, I can't hear you out of your muzzle somehow.
Just a minute. When you rent a room, short-term and long-term, it's still a business.
Right.
So we have to differentiate the renting rooms, a certain type and requirements, as not, it is a business or it isn't.
Okay, so it does say the type of use will be considered a business use, and anyone that wants to construct one of these will come in for site plan review. OJ?
According to our current land use plan, it is not considered a business use. Okay, a long-term apartment is considered a residential use. And that's why the density requirements, the number of units is different for an apartment than it is for an Airbnb or a hotel. That's the point of this, is that it's not considered currently a business use. And we're changing that to say it is.
Okay. Everyone good?
Yeah, excuse me, what number are you on?
Well, so on page 19, which is the third page in this here Lincoln land use plan order. But if you look at the bottom right on each page, it says a page number.
Sure, yeah.
They don't
I'm
go
on
1, 2, 3.
19.
Yeah, so 19, number 42, it's listed in red. This is a new definition. we're
Okay,
inserting.
okay, I get it.
Yeah,
All right, thank you.
all right. Are we ready to move on from this? All right. The rest of it just renumbering in blue. Page 20, the only change is the renumbering. All right, page 21, changing the parking requirements. 2A. Residential including dwellings, timeshare units, quarter share units, accessory apartments is new, or other similar types of occupancy as determined by the planning board. 2 spaces for each residential unit for the first 3 bedrooms, and then 1 additional parking space for each additional 2 bedrooms. Does anyone have any questions on that? All right, then B is stricken and included in A. And C is renumbered to B, change the parking requirements. Hotel, motel, tourist accommodation, lodging unit, boarding or rooming house, 1 1/4, 1.25 space for each unit or a bedroom. Does anyone have any questions on that?
Yeah, I'd just like to ask what page you're on.
I'm sorry?
21. It's
21.
21. Oops.
It's just, Mark, it's right here. It's Lincoln Land Use Plan Ordinance.
No, I know that, but I just asked you what page.
Okay. Okay. Let's see. D, timeshare was incorporated into A, and then commercial use was changed to business and uses otherwise not listed here. And then that is, the rest of it is unchanged. 1 space for each 300 square feet of public area. E is stricken. Then D, no change. E, just the renumbering. Then public assembly. Any theater, hall, or auditorium provisions for at least 1 space for each 4 seats, revised from 6 seats. Anyone have any comment on that? And then G, where 1 building is used for lodging or motel accommodation with a restaurant, 1 1/4 space for each rental unit, plus 1 space for each 4 seats. So basically, we just changed the parking requirement for each rental unit to match item B. Well, does anyone have any questions on that? Okay, H is just renumbering. And let's see. And then there's another prison here, which looks like it's going to be K. For any business that is operating without sufficient parking to satisfy current requirements, any request for expansion or change of use will not be denied based on parking requirements, so long as the total number of required parking spaces does not increase over the number required for the existing use. Anyone have any comment on that? No other changes on page 22. And then we're on page 29, no changes.
Yeah,
Page 30.
I put all the charts in there so you could see.
Yeah, I'm just flipping through it. So the next page, there's a change, is page 31. We added restricted multifamily residential housing to the land use schedule. It's going to be allowed in the general use. Village, VC is Village Center, right?
Correct.
Okay, and mountain residential won't be allowed in any other zone.
What
Any
page,
comment?
Jim?
What's that, Mark?
What page are you on now?
Page 31.
31.
Okay, I can't turn the pages fast enough.
I'm sorry, I'll slow down a little bit.
No, don't slow down. Not for me, but I'm just.
I think the next page is 32. There aren't any changes. Yeah. Page 33, changes to the dimensional chart. Village residential, minimum lot size from 12,000 to 15,000 square feet. General residential from 15,000 to 20,000 square feet. Minimum lot size, all of the uses in the village residential is, oh, excuse me, that first line was minimum lot size for duplexes. And the next minimum lot size for all other use, in village residential, it's going up from 8,000 to 15,000. General residential from 10,000 to 15,000. Anyone have any questions on that? All right, then percent of lot coverage is changed in the village center zone. It's been reduced from 80% to 70%. Any questions on that?
Yeah, Jim, I get one question.
Yeah,
In that zone, if you have a substandard lot, would that adversely affect you if you have trying to build on a substandard lot that's already been pre-approved?
so, a substandard lot is grandfathered.
But if you, but that application says you can only cover, you have to have more, less open space and more whatever, instead of a standard lot.
Paul, you have a question? Hold on, Joe. You're muted, Paul.
I was just gonna offer up the fact that they could always come in for a waiver or variance. To be able to.
Okay,
find-
are you talking about for lot coverage, Joe, or lot size? When you say substandard lot. Joe?
But if you're a grandfather, you shouldn't be put under those restrictions because you couldn't possibly build on some of the newer, some lots.
Right, exactly. I mean, I think what we're trying to accomplish is people, buying a house that has a little bit of excess land and chunking off that piece and squeezing something on there.
Some of us
Yeah,
have
so
20.
it won't affect any, it won't affect any lot that's already been subdivided.
That's what I want to make sure.
Yeah,
Well, the state is grandfathered.
new subdivisions will have to meet the new requirements.
Because I had some arguments about that at the town hall a couple of years ago.
Okay, yeah, so if your lots are already divided and they don't meet the new requirements, they're grandfathered.
Just want to make that sure.
Okay, yeah,
Make
yeah.
that,
All right, Cal, can you make sure the minutes reflect that Joe asked that question? It was answered. Thank you. All right, those are the changes that I have. Does anyone have anything else? All right, we have to have a public hearing. So is there a motion to open up public comment?
So moved.
Okay, second, Joe. All right, all in favor? Aye.
Aye.
Aye, yeah, all right. Any public comment? Motion to close public comment.
Motion to close.
Second, OJ. Joe's lead the motion. OJ second. All in favor, raise your right hand and say aye.
Aye.
All right. Any other discussion on this? Are we good to send this to the town warrant for approval?
Yeah, I have to have it, yeah.
We have to have a hearing to the general public to come and listen to it.
This is the hearing.
This is the hearing.
Yeah, I mean, we didn't make any changes. You don't have to have a second hearing.
I thought there might, oh, okay, I thought we had to have 2 hearings.
Only if we make a substantial change, and we haven't, no one's had any changes. All right. So is there a motion to send this to the town warrant as presented? OJ, all in, Joe second, all in favor, raise your right hand and say aye. Aye. Anyone opposed? All right, that carries. We got a couple of sets of minutes to go over. What did we decide on the work session, Carol? Did we decide we didn't need minutes?
Oh, I think we do need minutes.
Okay, but they're not
Brooke-
ready.
Brooke thought that we did not need minutes, but I did some research and, every time it says, every time we have a public meeting as a board, you have to have minutes.
Yeah.
They can be pretty cursory minutes. But basically the decision that we made, which was the changes that we were presenting to tonight's public hearing, that was the result of our work session. So,
Yeah, I mean, as long as I've been on the board, we always did minutes for the work sessions, and, I don't think it's a bad idea to have detailed minutes like any other meeting.
yeah. Anyway, so I did do research and we do have to have minutes and I don't have them ready.
Okay, so I'm on the meeting minutes for November 11th, 2020. Does anyone have any changes, comments, or corrections?
I don't.
Okay, nope. All right, is there a motion to accept the minutes as presented?
Motion to accept the minutes as presented.
Second.
Second, all in favor?
Aye.
Aye. Anyone opposed? Abstentions? All right, that carries. Meeting minutes for Wednesday, December 9th, 6 PM. Let's see who's here, myself, Joe, OJ, Steve, Paul. Mark wasn't here. All right. Anyone have any questions, comments, corrections on the December 9th, 2020 minutes? Is there a motion to approve as presented? OJ, is there a second? Joe seconded. All in favor, raise your right hand and say aye.
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 Opposed? Abstentions? Mark, you're gonna abstain, you weren't here on December 9th.
Did abstain. I just kept
Okay.
snapping, but that's okay. I abstain.
Okay, thank you. Let's see, I don't have the other. Carol, Les, right before the meeting started, you got some information from the Chief Morris about enforcing zoning requirements.
Yes, I sent you my very colorful spreadsheet. I mean, I've looked at the statutes because Butch had referenced the word "the way," and I knew "the way" from some criminal work that I had done years ago. So I did do research for that, and I gave you all the statutes that apply on that handout that I sent you. But I sent it right before the meeting or during your meeting. But what he said was the only thing that he can enforce on a private road in a development like we have for Clearbrook and, you know, for all the other private roads that we have as part of the developments, they can just, I think the things were, let's see, where's my sheet? Oh, here it is. Anyway, it's this very colorful item here that I sent you. So the RSA has to do with motor vehicles, and it's RSA 259-125, which defines way. And it references in the part 2 of the statute 4 other statutes. And those 4 other statutes have to do, the first one is RSA 265-71. It's called additional parking regulations. And that's the parking regulations that the Commissioner of Transportation, which of course is not us, can place signs to prohibit the stopping, standing, or parking of vehicles on any way if it's dangerous or interferes with the free movement of traffic. So it doesn't apply. So the second statute referred to is RSA 265-79, and that has to do with reckless driving. So if we have somebody who's doing reckless driving on our private roads, the police department can enforce this particular RSA and has authority to pick people up, but that has nothing to do with our parking issues. The next one has to do that they have authority on private ways, has to do with RSA 265A:2, which is driving or operating under the influence of drugs or liquor. That's not helpful for us. The next one is RSA 265A:3, which is aggravated driving while intoxicated. Once again, not helpful. And that's it. So,
Excuse me, Carol.
Pardon?
Excuse me. When I was in the police academy, we were told if you were driving in a public way, which is intoxicating or anything else, you still could be arrested.
You can, that's what I'm saying.
Yeah.
I'm saying that these are the things that a police officer from Lincoln can take action on a private, public, or a private way. They call it way now instead of public way. That's used to be public way, but now it's way. And those are the only things that they have authority to take action on those public ways. So, I mean, there's a few other things like there's something, a specific statute has to do with cisterns, like if somebody's parked and the fire chief can't get to the cistern for a fire. they can remove those. So those are very specific and isolated things, but not to address our parking issues.
Okay. Anyone have any questions for Carol? Thanks, Carol.
Okay.
Any other business?
Hey, Jim, just.
Yeah,
Remember you just got, about 2 months ago, we were discussing about disturbance of property. For building a property, building a house, how much land you can disturb.
right.
Well, you might want to look under Syntax court ruling down in the southern part of the state, because we had a similar case down there where the guy disturbed more property than he could, ended up going to the state Supreme Court, and they overthrew it and wrote a whole new law on it.
Okay. You're talking for the purposes of the stormwater management ordinance.
Well, the thing is, if you got to be a lot, you can't get behind it. You got to excavate some land, be more than 15,000 square feet. But if you put it back in under Simplex, they can do it.
Okay.
Just thought to bring it up.
Yeah, okay. Cal, can you take a look at that when you have a chance? If you get a chance. Paul?
Yeah, I think that the board ought to take a look at the stormwater protection and see if there's something we can't do about it. I mean, if the 15,000 square feet, I think should look at whether there's a post and a pre and how much is actually getting disturbed. I think it's getting pretty costly for homeowners and developers to do that. I mean, I think the intent is good, but I think that we could definitely tailor it a little better, so that, you know, the amount of impenetrable surface is the determining factor after they're all done.
I agree with you, Paul. There's been several state Supreme Court rulings on it. Nobody even pays attention to.
So I think the issue arises where you store the excavated material on site, and that becomes now included as part of the disturbed area. I think
Also
that's,
digging it.
But I think there's two things. I think there's two things here, Jim. I think there's the impenetrable area that's our impervious area that's left over after the construction is done. But I also think that there's state laws and rules governing sedimentation and erosion,
right.
which is actually would address those concerns that you have. The sedimentation and erosion control of the DES regulations, I believe, God bless you, address a lot of those concerns.
Right.
But I think, you know, that the town, because we have such small lots, you know, the disturbance is really triggering some problems, I think, for the town, Ron, and, you know, the people over at South Peak, because they're small lots and, you know, they're having to pay a lot of money to put in these exorbitant stormwater protection things. And I think if we take a look at actually what they're disturbing in the end, if we could find a way to do that, we obviously need an engineer to be able to tell us that. But it might go a long way to helping out some of those people and to help Ron not have to go through so much when he's doing an inspection. Just a thought.
Yeah, no, I mean, I think that was the intent of the ordinance. We were more concerned about post-development runoff.
That's not what's being happening. That's
I
not what's
understand that. Anyone have anything else?
I don't. Anybody else? Yeah.
No. Is there a motion to adjourn?
Motion adjourned.
Joe J seconded. All in favor, raise your right hand and say aye. Aye. All right. Good night.